Before we resume the hearing, I should explain that we've had a technical problem which has been fixed. But if it were to occur again, the effect might be that we lose the live stream of the hearing. If that happens, anyone wanting to watch the hearing will have to wait until tomorrow, when the hearing, when a recording of the hearing will be available on our website at jcpc.uk. In the meantime, I can return now to Mr. Mumford and invite you to continue your submission.
My Lord, I'm grateful. Before the short adjournment, I was about to take your Lordship to a case that Mr. McGrath mentioned in his submissions on the question of whether or not the panel could correct a procedural defect in his failure to serve a claim form. And that case was a case called Great Panorama, which is at page 14539 of the bundle. Lord, I don't need to take you to any particular passage, but one can see, well, perhaps if one looks at paragraph 5, that might be helpful. 5 and 6, as those are the passages that the learned friend took you to. But what your Lordships will see was that this was a case where there was a claim form, which it appears had been served on the defendant to the claim. And what was sought to be done was to join 2 further respondents as defendants to the claim form, those respondents both being companies within the jurisdiction. So there was no question in this case of the sort of difficulty that Mr. McGrath faces, which, as I said before the adjournment, was that he's failed to serve the originating process on me at all that's required to found the court's extraterritorial jurisdiction over me. This case simply isn't on point. So, my Lord, that's the absence of a claim form. We say further, even if one could somehow proceed on the basis of a claim form, and even if one could somehow correct the absence of a claim form, in a case such as this, where all that is sought is freezing order relief against my client, we say still it's not the sort of claim for relief with which the gateways are concerned, in the sense that I set out before the adjournment. It's not a claim for final or substantive relief. It's not the sort of claim to which one would put in a defence or an acknowledgement of service. It's not the sort of claim to which one would suffer judgment in default of appearance. Indeed, it's meaningless to talk of there being a final judgment for a freezing order in the sense of some final adjudication of a right. A freezing order, unlike many of the sui generis sorts of injunctions that have been under consideration in the debate about the power question, is inherently provisional. It's inherently an order which is granted pending some further order or ultimately satisfaction of a judgment. One never gets a permanent freezing order. And one never has any final adjudication of a right to a freezing order. On the contrary, the adjudication that takes place is of the right to which the freezing order is ancillary. One obtains one's freezing order at the outset of the proceedings, not at the conclusion. And one obtains it on the footing of a provisional assessment of the merits of one's underlying claim. And that is simply not reconcilable with the scheme of the rules as I have outlined it. It's also not, well, my learned friend made a suggestion, let me put it this way, that one could square the freezing order application with the sort of adjudicative process that CPR 7.3 and following appears to envisage, on the basis that when one serves an application for a freezing order, one summons the respondent to appear at an inter partes hearing, and then there is an inter-parties hearing. But that's not the sort of adjudicative process that the rules are concerned with. There's still no adjudication of any right. There's a provisional assessment made of a claim to some other right, and then provisional relief is granted on the basis of that. Again, still at the outset of the proceedings. So that's no answer to the point. It's also, in my submission, meaningless to talk about an application for a freezing order as being the sort of claim that one could testify to having a real prospect of success.
Mr. Mumford, Lord Legate has a question.
I beg your pardon.
Can you help us with what you say would be a paradigm case that falls within the injunction gateway? And
Yes.
what your answer is to the argument that if all the gateways, including that, are directed to some underlying cause of action, then you're going to have to find that somewhere else, because an injunction isn't an underlying cause of action. It's a remedy.
One could still have a cause of action for an injunction.
But it's going to be claiming tort or something, isn't it?
Well, the first point, my lord, is that one needs to bear in mind that the injunction gateway was first enacted at a point when there was no gateway for claims in tort. The gateway for claims in tort wasn't enacted until 1920. I think the injunction gateway dates back some 20 or 30 years before that. So that bears on the interpretation one wants to give to it. But even if claims in tort have now been taken out of the scope of the injunction gateway, having been within it originally, one still has further claims for injunctions that are substantive claims that wouldn't necessarily fall within another gateway. For example, claims for injunctions under equitable rights. An injunction to restrain a breach of fiduciary duty. An injunction of the sort that is being considered in the cases that my learned friend was talking about yesterday, where one talks of having a novel equitable right to the injunction as final relief, a Cartier type injunction, for example. One can characterize those as injunctions for which one has a cause of action. They're injunctions that are granted on a final basis. There's some adjudication of one's entitlement to the injunction as final relief. But they're all very different to freezing orders. One might also bring quia timit injunctions within the gateway, the injunction gateway, because they, unlike freezing orders, are also injunctions that can be granted on a final basis in protection of some underlying right to the injunction. Quia timit injunctions are not provisional in the same way that freezing order injunctions are. Quia timit injunctions found upon the existence of some right of which there's a threatened infringement, and one can have a trial as to whether or not one has the right that's threatened to be infringed and whether or not there is a threat of infringement, and then can grant a final injunction on a quia timit basis. That's the sort of thing that the gateway is concerned with. So it's by no means OTOs. So as I was saying, my lords, it's the fact that one's got to testify to having a real prospect of success is, we say, another strong indicator of the sort of claims that, my lord, Lord Sales.
Yeah, sorry, just before we leave that point, what would be your answer to the point made by Lord Nichols in Mercedes-Benz at page 11768, where he talked about the application of Order 11 in relation to the Channel Tunnel case?
Where he suggests that one could have a writ claiming the relief on its own. Sorry, let me just pull the case up. Is that what, but from recollection, is that the passage my lord's talking about?
Well, he starts by saying you could have a writ claiming the relief by itself.
Yeah.
And then at 11768, he, if you like, extends that point to make an observation about the relief sought in the Channel Tunnel case. Can you see, for completeness, I add that the position under Order 11 would appear to be the same in respect of interim relief of the character discussed in the Channel Tunnel case?
Yes. Well, I would say if all one is doing is making an application for interim relief, then that wouldn't be within the scope of the gateway.
So the Channel Tunnel case would be outside the scope of the gateway. Is that what you're saying?
Yes. That too is if all that's in the claim form is in fact an application for relief of an interim nature, pending some further adjudication of a right, I would say that's not within the scheme of the gateways.
Yes, thank you.
Just following up on that answer, the rules that you've been referring to were enacted, I think, in 2000. Is that right?
Yes.
And would I be right in saying that your interpretation of the rules, in particular, relying on the definition of claim and claim form, is wholly consistent with the view of the majority in Mercedes?
Yes. Entirely consistent with it. Yes.
Yes. Thank you.
Indeed, I might go so far as to say that the assumption one would naturally make is that Parliament, when enacting these rules, intended to adopt the same interpretation.
Thank you.
So as I was saying, my Lord, it can't.
I'm sorry to interrupt. Just thinking about that passage in Lord Nichols' judgment, the Channel Tunnel case was effectively an anti-suit injunction, but because there was a contractual agreement to go to arbitration, I think.
Yes. I beg your pardon, my Lord, I didn't mean to cut across you.
No, not at all. Do correct me if I'm wrong. So in that case, there was a contractual right. If there were a dispute, for example, as to whether the disagreement in question fell within the scope of the arbitration clause, then that would be an issue capable of judicial determination.
Yes, my Lord. I didn't mean to suggest otherwise. If one could seek a final injunction, one could seek a final adjudication on whether or not one was entitled to an injunction restraining the arbitration.
Yes, exactly.
And if one were to bring that sort of claim, I would say it was within the scope of the clause, of the rule.
Yes.
My point was simply that if one confined one's claim form to only the interim injunction and sought the final relief elsewhere, that wouldn't be within the scope of the rule. So yes, as I was saying, my lords, it can't be meaningful to describe one's claim as to a freezing injunction as one which one has a realistic prospect of success. There's no such assessment that the court undertakes. The claim that's being referred to is clearly the claim to the final relief. If one's to assess it with reference to a realistic prospect of success, a claim at some further point is going to be adjudicated upon on the balance of probabilities. And that never happens with a freezing order. Nor can it be said that the claim which has a realistic prospect of success for the purposes of that rule is instead the claim ancillary to which one gets the freezing order. In my submission, the natural construction of the rule is that the claim that's being talked about in CPR 7.5 is the claim you're seeking permission to serve out. Not your, it can't work that way. My learned friend made a suggestion which he didn't fully develop in his submissions yesterday, that actually the requirement for an affidavit or witness statement of a real prospect of success can't be as big a problem as I suggested it is, because one has a similar provision under the English rules, and yet under the English rules one can serve out applications under section 25 of the CJJA. It's right that there does appear to be a tension there, but I would say that doesn't assist his case, because we're concerned with a scheme of rules that doesn't have any express provision of a gateway for service out of interim applications. And the fact that the framers of the English CPR may have crowbarred in an express provision for serving out interim applications without having worked through all the ramifications for the rest of the rules of doing so is not a reason to construe the BVI rule differently. We're looking at the problem the other way round. Where one doesn't have any express provision for interim relief, can one construe the rule as referring to interim relief? In that circumstance, I'm quite entitled to say that the fact that one's got a provision for an affidavit of this sort is an indicator that the answer is no. As I said at the outset, none of this analysis is affected in my submission by how one rationalizes a freezing order. Because what matters for present purposes is, as I say, the fact that a freezing order is inherently interim and provisional. It doesn't matter whether one justifies it on the basis Lord Nichols justifies it, or one justifies it as a cyanamid type injunction, or indeed an abuse of process type order. In fact, my lords, I would go this far. If, and it's not what my learned friend is advocating in this case, but if one were actually to go the whole hog and adopt the Australian Cardile rationalization of the freezing order, it would actually generate another problem for my learned friend's case, which is that such orders made out of the court's inherent jurisdiction to control its abusive process are not regarded as injunctions. Cardile analyzes that and looks at the jurisprudence in England and Australia and comes to the view that it's not appropriate to call that sort of sui generis abusive process directed order an injunction at all. So if one is to take the position that the rationalization affects the result, in my submission, it just lands my learned friend in a different problem, that he doesn't have an injunction claim at all. But that's not the rationalization I urge upon your lordships. As I understand my learned friend does, I too say that these are freezing orders are a species of interlocutory injunction granted under Section 24 of the BVI Act. But I simply identify that if one were to depart from that rationalization, it would have a knock-on effect on the scope, on the ability of my learned friend to come within the gateway in a different way. It also, in my submission, doesn't make a difference to the analysis of the rule that I've argued for and that's adopted in Mercedes, that the final adjudication of the right will take place elsewhere. If the power exists to grant a freezing order in aid of foreign process, then the eventual adjudication will take place in some foreign court. But that doesn't make a difference to any of this analysis. Lord Nichols appears to have thought that it did in Mercedes. Lord Nichols took the view that if the application for the interim freezing order was the only thing that was in your originating process, then it was necessarily the substantive relief you were seeking, and that was the end of the matter. And I understand that to be what my learned friend urges upon your lordships. And in that regard, Lord Nichols draws upon Rosler and Hilbury, says, well, the real issue is whether or not your application is ancillary to some other, bigger, more important claim. And if you've only got an application for a freezing order in your originating process, then it's not. Therefore, you don't fall foul of Rosler and Hilbury, and you're okay. You can come within the injunction gateway. But that's to misunderstand the way that we put the point. What makes a freezing order inapposite for Rule 7.3 is not the fact that it's usually ancillary to some other claim that's more important to you. It's the fact that it's inherently interim and provisional and not something to which one has any right that could be adjudicated upon. That's what takes it outside the rule. And that is true regardless of whether the relief is sought, the final relief in the underlying claim is sought within the jurisdiction or without. Indeed, if Lord Nichols is right about that, and my learned friend is right, and I'm wrong about that, and that what matters is simply whether or not there's some other claim, then it produces an odd result, because it's well established that one needs to have obtain leave for each of the claims, in inverted commas, that one makes in one's claim form. One can't bring in claim 2 on the back of claim 1. They have to get through their own gateways. Now, when a freezing order is served in aid of local proceedings, sought in aid of local proceedings, where the substantive claim is proceeding locally and is in one's claim form, and one seeks to serve a foreign respondent, one would never suggest that the freezing order was itself a claim that had to come within a gateway. One would decide whether one's underlying claim, one's claim in contract or tort or whatever it was, had to come within a gateway. But you would never apply the principle I've just mentioned to say, oh, well, they can't have their freezing order, because that's another claim. And we know that all claims have to come through their own gateways. But on the logic of my learned friend's case, that all changes the minute that one seeks to serve a freezing order in support of proceedings that are abroad. All of a sudden, the freezing order becomes the claim. All of a sudden, it becomes the thing that you have to get through the gateway and are entitled to get through the gateway. And we would say it can make no sense that a freezing order has this protean Janus-like quality. It's either a substantive claim of the sort that the rules envisage, or it's not. And the answer can't depend upon what other relief one's seeking. And we say, for the reasons I've given, it's clearly not. Finally, my Lord, on this point, there was some suggestion in my learned friend's submissions yesterday that one ought to be able to serve out a freezing order because one can get a freezing order in aid of enforcement proceedings. And there would be no difficulty with service out of the freezing order once enforcement proceedings were underway. Why not, he asks rhetorically, can you get them sooner than that? Well, my lords, the answer is the answer I've given. And indeed, his submission rather highlights a point, which is that the enforcement gateway is expressly drawn up, and one sees it on page 13568, subrule 5. Claim may be served out of the jurisdiction if a claim is made to enforce any judgment or arbitral award made within the jurisdiction. That presupposes that judgment has been given. The framers of the rules have determined that it's only appropriate to assert extraterritorial jurisdiction over a defendant out of the jurisdiction with respect to enforcement once one has a judgment. What my learned friend's seeking to do is to use the injunction gateway to get around that limitation. But as I say, he can't for the reasons that I've set out. My Lord, those are my primary submissions on the question that arises as to the gateway. There is a secondary point on the construction of the gateway, which my learned friend didn't address in his speech at all, which is whether or not, if I'm wrong about all of this, and one can serve an application for a freezing order and nothing more out of the jurisdiction, is it nevertheless an injunction that restrains acts within the jurisdiction? Now, the relevant injunction is at page 852 of the bundle. This is the injunction as it was granted by Justice Chivers at the original ex parte hearing, and 852 should be that page of it, which concerns the relief against Dr. Cho as the second respondent. And one sees the operative parts of the injunction are that in paragraph 6, Dr. Cho be restrained from in any way disposing of, dealing with, or diminishing the value of his assets within the Virgin Islands, in any way disposing of, diminishing, or dealing with the value of the shares, whether they are in or outside the BVI, whether in his name or not, and whether owned jointly, beneficially, legally, or otherwise, and affecting or allowing to be created or effected any changes, variations, or amendments to any agreement, trust, or any other similar arrangement in relation to which the shares are held. Now, your lordships may have picked up from our written case that we say it is a principle that one, in order to come within the injunction gateway with respect to acts within the jurisdiction, one's injunction has to be confined to acts within the jurisdiction. And that one can't get an injunction that in fact restrains acts out of the jurisdiction simply on the basis that it includes acts within the jurisdiction. And the authority for that is a case called Conductive, which I might just take your lordships to, is at page 10294 of the bundle. The start of the case is at 10277, and the relevant passage, as I say, 10294. And this was a patents and breach of confidence case where injunctions were sought enforcing alleged rights of confidence in various ways. The detail doesn't matter, but the propositions that I'm interested in are at paragraphs 61 and 62. And perhaps, my lords, you might just read those passages to yourselves. My Lord, Lord Briggs.
I suppose there must be some rational limits to that proposition. And suppose the issue in question was the disposition of shares within the BVI, and the respondent to the injunction lives abroad and has a broker in the BVI through whom he normally makes share transactions. Can he say, well, you can injunct me from coming to the BVI to tell my broker to sell the shares across the desk, but not from ringing him up from let's say, Jamaica?
Well, my Lord, I think I'd be prepared to accept that if one has an agent within the jurisdiction who acts on your instructions given from outside the jurisdiction, that can be treated as an act within the jurisdiction for these purposes. But the sorts of dealings with respect to the shares that this injunction extends to aren't limited in that way. Dr. Cho is restrained from in any way disposing of, dealing with, or indeed diminishing the value of his assets within the BVI. Now, that in my submission is something that could quite readily be done by acts taken by him purely outside the jurisdiction, indeed ordinarily would be. And it's by no means necessary that for such acts to take place, some agent of Dr. Cho, some broker of his, has to do something within the jurisdiction. It may well be that the result of a disposition would be some step taken by the local registered agent to alter the share register. But that wouldn't be an act of Dr. Cho in my submission.
But if the transfer of title to the shares depended upon the register being altered, then it would it?
I don't think I would accept that. I mean, Dr. Cho, the relevant act of Dr. Cho that's being enjoined is his transfer of his beneficial interest in the shares to some transferee, which may be a transaction that takes place wholly in Hong Kong.
Yeah. Yeah.
But a fortiori, other sorts of acts that might have the indirect effect of diminishing the value. I mean, what this is in part intended to capture is what Dr. Cho might do as a director of Broad Idea with the assets of Broad Idea that might indirectly diminish the value of his shares in Broad Idea. But the board of Broad Idea can sit anywhere in the world. One gets that from Article 92 of Broad Idea's Articles of Association, which is, for your reference, we don't need to turn it up, at page 2787 of the bundle. My learned friend says, well, it's all okay because the acts are nevertheless felt within the jurisdiction because they impact on an asset in the jurisdiction. But with respect, that's not the test that the injunction gateway poses. The injunction obviously operates in personam, not in rem. It's not an attachment of assets. And hence the focus upon where the relevant acts take place. But the gateway is not framed with reference to where impacts on assets are felt. It's framed with reference to where acts take place. May be thought to be another reason why the gateway is not really apt for freezing injunctions, actually. But my lord, in my submission, my learned friend has to cross that hurdle as well. He's got to demonstrate that he has an injunction which is confined to acts within the jurisdiction. And this injunction at page 852 is not so limited. So for that reason too, the court was right to set aside the permission to serve out. My lords, those subject to any questions you may have, those are my submissions on the territorial jurisdiction question. I was going to move on to say a few words in the short amount of time I have left about the power question. My lord, on that, as I say, we make common cause with Mr. Morgan, and I gratefully adopt his submissions on it and don't intend to repeat them. I might just make a small handful of, I hope, relatively discrete points. And these centre upon the question which I think was vexing your lordships this morning as to whether or not the right rationalisation of a freezing injunction is that actually it acts in support of some future right to the enforcement of a judgment rather than some present right, and whether actually the dictum in, or indeed ratio, in the North London case, the North London Railway case, could accommodate such a legal right. My Lord, in my submission, that analysis neither works nor is necessary to accommodate a freezing order. First, so far as concerns the point about the North London case itself, and in response to the questions that were posed by Sir Geoffrey Voss to my learned friend, we say that a future legal right of the sort in contemplation is not the sort of thing that North London Railway was concerned with at all. It's talking about rights that exist independently of the court's process. That's the whole point about North London Railway. One's got to have a right that exists independently of the invocation of the court's process to be able to get an injunction. A second order right of the sort that's now under consideration, a second order right to have the court's process not abused, or to have the a judgment in due course enforced, is by definition, we would say, not the sort of right that North London Railway is concerned with. It would be circular to say that a right arising out of the engagement of the court's process is what is needed to engage the court's process. So in my respectful submission, one can't square this analysis that my lords are proposing with North London Railway. If one is to go down the road of analysing the injunction in this way, one has to accept that it represents an entirely different way of rationalising the injunction. Secondly, in my submission, it's not necessary to rationalise a freezing order in this way, or indeed in the way that Lord Nichols does. And we don't accept that Lord Nichols's analysis is correct. I think the premise of much of my Lord's questioning this morning was that it should be taken to be right, and indeed my learned friend described it as uncontroversial yesterday. But it's controversial to us. In our submission, you can rationalise a freezing order as being in protection of a present right. And in the usual case where one's seeking it in aid of domestic proceedings, that's a perfectly satisfactory rationalisation of a freezing order. Certainly a claimed present right. It may or may be right, as my Lord Sales said, that the right may turn out not to have existed. But that's not an objection to the rationalisation, because that's true of any right that one litigates about. One may turn out to be wrong about it. That's why one has trials, and that's why one grants relief on an interim basis provisionally, on the basis one has a real prospect of establishing one's right. But there is, we would say, at least in the case where one is acting in support of local proceedings, a present right, or at least a claimed present right, that one can say the freezing order is pertinent to, or is protecting. One doesn't need to resort to the sort of second order future right that's under consideration. The fact that, and indeed we'd say in this regard, there isn't really the sort of distinction between cyanamide injunctions and freezing orders that my learned friend was urging upon your lordships yesterday, and that underpins Lord Nichols' analysis. We would say a freezing order looks to the protection of a claimed right just as much as an interlocutory injunction does. The fact that the form of the interim relief that you get may not quite frank the form of the final relief that one would get, whereas with an interlocutory injunction it does more closely frank the form of relief one would get, is neither here nor there. One's still protecting the right in the sense that one's protecting in the same sense that one's protecting it in an interlocutory case. Put the other way round, one can characterize an ordinary interlocutory injunction as being concerned with the protection of the ultimate enforcement of the right. It comes to the same thing. I mean, in Mr. McGrath's example of the tree, one gets an injunction restraining the chopping down of the tree because when one gets to judgment, one wants the tree still to be there. In both the freezing order case and the ordinary cyanamide case, the injunction is avoiding the stultification of the ultimate judgment. But the ultimate judgment's will only arise because one's got some right that one's claiming that's going to give rise to a judgment. So we say that there isn't this stark dichotomy between freezing order cases and other interlocutory injunction cases that requires one to throw out the Siskina reasoning and North London Railway. They are all interlocutory injunctions within the ambit of Section 37 of the English Act or Section 24 of the BVI Act, and they're all subject to the well-established jurisprudence that applies to such injunctions. And we say if the distinction between the two falls away, then so does the rationale for analysing them in some radically different way. And if one doesn't analyse them in some radically different way, if they are doctrinally to be regarded as another species of interlocutory injunction, then we say, well established, has been the position for 130 odd years, that there has to be some present claimed locally justiciable right to justify the injunction. And we say a foreign judgment cannot be equated with a future judgment on such a right domestically for these purposes. A foreign judgment is not recognised, has no effect whatsoever, and until it's given, and is then regarded as giving rise under the local law to a debt, an implied promise to pay. My own friend's approach to the freezing order, what one's doing in the case of a foreign judgment is granting a freezing order in support of, so far as the domestic law is concerned, a cause of action that will not accrue for several years hence, may never accrue. And we say that is a very dramatic refashioning of the conception of a freezing order. And one wonders what the corollary of refashioning the freezing order in that way would be. If one can get a freezing order in support of the cause of action under a future foreign judgment that's several years down the track and entirely contingent, what else can one get a freezing order in support of? I mean, it does away with the vera cruz, but it goes, my Lord Legate.
I was about to say, Mr. Mumford, that one thing you might get a freezing order in support of is a claim that's going to accrue next week, which at the moment can't.
Indeed, but it's throwing the baby out with the bathwater to solve that particular problem, if problem it is, by saying that one actually attack freezing orders actually attached to future rights under judgments rather than under present claimed rights.
I don't really see a difference of a qualitative difference, because you've always got to look at whether there's likely to be a future judgment in order to justify your freezing order in any case. That's the whole point of the exercise, to see whether there's likely to be a judgment in your favour and whether it's likely to remain unsatisfied if you don't get an injunction. Those are the two elements.
Yes, well, but I would say the lack of distinction is a reason why one is back within the analysis, the conventional and established equitable analysis of North London Railway and so forth, because there isn't a distinction between looking to the judgment and looking to the and protecting the right. And what one can't say that Siskina has gone wrong because it's misunderstood what freezing orders are. Freezing orders are like interlocutory injunctions in this way. So one has to throw out all of that reasoning. One has to depart. One has to set aside Siskina. One has to depart from North London. one has to depart from all of those subsequent Privy Council and Supreme Court decisions, which have indicated that the Suskina remains good law, subject to the fact that other species of injunction may be allowed to develop. And as to those other species of injunction, they're not, in my submission, on point. They are the fact that equity may be flexible enough to generate causes of actions or claims for other sorts of injunctions as final substantive relief is neither here nor there when we are concerned with injunctions as interim relief and the rules under which they operate, and they inherently require there to be some other right to which the injunction is appurtenant. Nor we would say are queer timid injunctions an exception or a reason to depart from ordinary principles, because they are founded on a present right as well. It may be the infringement of the right is threatened, but a queer timid injunction founds upon a present right. Whereas the right under a foreign judgment doesn't exist at all. Finally, my lord, if one is to adopt the Australian approach, one can't cherry pick in my submission. The Australian rationalisation of the freezing order as effectively there to protect the court's process from being abused is founded on an entirely different statutory jurisdiction or indeed inherent jurisdiction. I've already made the point that the corollary of adopting that would be that actually one's not dealing with an injunction at all. But one can't simply transpose that jurisprudence into England, where under section 37(3) of the Act, it's already been acknowledged that these are a species of injunction that exists within the section 37 jurisdiction. And the same approach, although the statute is not in the same terms, the same approach is to be read into the BVI. It involves, my lords, a fundamental rewriting of the whole doctrinal basis of the freezing order. And as my learned friend said, it's not necessary to do so, because to the extent this is thought to be a desirable thing to do, the BVI legislature has stepped in and has solved the problem, if problem it ever was. And its significance can only be for the particular facts of this case, and indeed, really for the cost consequence of this case. And as I said before, it's otherwise entirely unnecessary, because Dr. Cho is already subject to a worldwide freezing order that catches his assets in the BVI. My lords, those were my submissions. Unless there's anything I can assist, my Lord Sales.
Sorry, just to make sure I've understood one point. I understand what you say about the BVI legislature correcting the lacuna in terms of power by section 24A. Does it remain the case that there is a difficulty with the rules on your submissions in relation to the construction of the rules, that one couldn't get leave to serve out even if there's an exercise of the power under section 24A?
Yes. Yes, indeed. It's striking that the legislature did not take the opportunity at the same time as legislating to address that. But no, the new Act does not address the gateways. The gateways stand as they are, and I would say the same problem would arise for Mr. McGrath if he were to reapply under the power.
Yes, thank you.
My Lord Briggs.
On that point, I thought I'd read somewhere in these voluminous papers that the chairman of the BVI Rules Committee indicated in a lecture or a seminar of some kind that a relevant change in the rules was being thought about.
I think you may have read that in my submissions.
Yes.
I think it is right that the rules are under consideration. I think there's a more general reconsideration of the gateways. Further than that, I'm not really able to go.
Yes.
But I'm sorry, brother.
That was just an aside. My more substantial question to you is really this. Coming back to the question of what North London Railway, you made brief reference to other species of injunction, like Norwich Farm, and perhaps explained in the presentation of the winding up petition. Do I understand you to say that there may or may not be exceptions to the cotton principle, but even if they are, that doesn't work for freezing orders.
Yes, that's my submission.
Yeah,
Because
I thought
the freezing order is inherently associated with some other right.
yes. Well, they're pretty Feldian, some of them. As I understand the Cartier injunction, the equitable duty to assist isn't a pre-existing duty, it's just a duty when a court tells you.
Well, I don't know, my lord. I would characterise it as much like a Norwich Pharmacal duty, one that arises out of one becoming, in some sense, mixed up in another wrongdoing. Of course, the other point is
said that somebody is under a Norwich Pharmacal obligation until told to do it.
Well, it may not be that it's not an obligation that one could sue on independently, but that is how it's explained in terms of a duty that arises out of becoming mixed up in another's wrongdoing.
Yes,
In the case itself.
yes. I'm just slightly wondering whether there is a pre-existing duty in the sense, and one which exists independently of the court's process, as you described the North London Railway principle.
Well, in my submission, one can talk about it as a duty that generates a right to relief as an end in itself, in a way that one can't with a freezing order or an ordinary interlocutory injunction. They're not inherently parasitic upon some other right in the way that interlocutory injunctions and freezing orders are, and that's where the thrust of my submissions lies.
Yes, thank you.
Thank you very much, Mr. Mumford. It doesn't look as though there are any other questions for you. So we'll turn then to Mr. McGrath for the appellant's reply.
Thank you, my lord. My lord, the thrust of the broad idea challenge to the freezing order was and is essentially a jurisdictional challenge with some matters added on at the end. And I don't mean to belittle the factual issues that are referred to at the end, but I thought it's right to point that out, and because we say that that's really the way it was focused on before the Court of Appeal. And your lordships will see that once they've decided that in the absence of an underlying cause of action in the BVI, the freezing order against broad idea fell away as a matter of jurisdiction. And the reason I say that, my lords, because of the limits in time, I should just say and make clear, as I've indicated once before, that in the Roy Cho appeal, the issues, the factual issues, if I can put it that way, in terms of good arguable case, risk of dissipation, etc., are all reserved to the outcome of the jurisdictional battle before your lordships in this appeal. And one might think would be a little odd to engage in that battle for the purposes of broad idea when the issues are being left over for the purposes of Roy Cho. All the more so where the arguments based upon risk of dissipation and good arguable cause of action are premised upon the claims against Mr. Cho, Roy Cho, and the risk of dissipation stems from and derives from Roy Cho's conduct and how we say that impacts on broad idea via his control over broad idea. And I note that there is one point that was raised by Mr. Francis Choi. I use his first name simply because, to make it quite clear, I'm talking about Mr. Choi rather than Mr. Cho. In his first affidavit, he said if the injunction against broad idea were to be maintained, then he would want to be able to participate in some form of buyout, so that he could take what he considered was his share of broad idea, if I can use that broad language. And just for your lordship's note, that's paragraph 30 of Choi 1, page 2500. And obviously any such option, if exercised, would be one before the BVI court, importantly for the reasons I'm going to go on to develop, with full transparency as to Broad Ideas' financial standing and position, rather than any attempt to contend that a 49.9% share in Broad Idea is without more to be equated with 49.9% of Broad Ideas' assets, which is the premise upon which the share swap agreement was proposed by Roy Cho and Francis Choi. And I'll come on in a moment to deal with that. So I just make that point clear because it won't be possible for me to get into all the factual issues. I very much focused on the issues of principle, but I do want us not to forget the context of this application, and that is that CCL, the appellant, has brought these proceedings as a victim of a substantial fraud, as set out in Action 399, and that the central figure to that fraud, or alleged fraud, is Roy Cho, and that he's alleged to have asserted influence over the Convoy group, both Convoy and CCL, in order to procure them to enter into the transactions which are labelled impugned transactions. Now, I'm not going to trouble your lordships with the details of that, but as you will see, if one looks at the Hong Kong Court of Appeal judgment, they're of a very serious nature relating to breaches of fiduciary duty and dishonest assistance. Now, the court in the BVI, Mr. Justice Adderley, and also the Court of Appeal, had to approach this matter from the basis that there was no challenge on the merits of the claims against Roy Cho, and there was no challenge on risk of dissipation. Now, if we put every other example of Mr. Cho's conduct to one side, we are still left with the most overwhelming case of a risk of dissipation one can imagine, because this is somebody that used companies as nominees to disguise ownership, to assert disguised control in order to procure companies to enter into transactions for personal benefit. And when one sees that and realizes this is a good arguable case, one starts to think back to Mr. Justice Arnold's rejection of risk of dissipation in VTP and Nutritech, having found a good arguable case that Mr. Malofiev had committed the fraud using offshore companies. And the Court of Appeal in that case put short shrift to the idea that one could not infer risk of dissipation in those circumstances. So it's very important to remember the background. And then it's also, when criticising Mr. Justice Adderley and what's in his judgment, we need to remember that Mr. Choi, Francis Choi, turns up in front of Mr. Justice Adderley, first affidavit, saying very carefully by reference to submissions that had been made very properly by Mr. Addo at the ex parte stage for CCL, very carefully by reference to that, that he's an innocent shareholder, a bystander, caught up in Mr. Roy Cho's activities, and that he wants to be able to extract 49.9% of the assets which are presently covered by the freezing order under this share swap agreement. And yes, there is an agreement, and yes, there's a shareholder consent to that agreement, and we even have a balance sheet with an accountant signing off on it. But the two people who have signed up to this arrangement are Mr. Cho and Mr. Choi, and the consequence of the arrangement would be the extraction and excising of 50% of the only known assets of Broad Idea under it. And I'll come on in a moment to talk a little bit more about the worrying aspect of that. But one was put in the position of Mr. Justice Adderley. having been presented with a picture that Mr. Choi is this innocent bystander caught up, and then we have the whole situation about Action 2922, which Mr. Choi joined himself to clear allegations against him, which hasn't yet happened. There has been a strikeout application issued, but the hearing has been adjourned and it hasn't been relisted. Now, the point of this, and it's very easy to be confused, Action 2922 is not there to support the existence of a judgment against which we will be enforcing in the BVI. Whether something happens in the future, that's by the by. Action 2922 relevance to present proceedings is that it rides a coach and horses through the impression that Mr. Choi sought to give of his position with Mr. Cho and his involvement, because Action 2922 involves very serious allegations against Mr. Choi for whitewashing Mr. Roy Cho's fraudulent scheme by using nominees to acquire shareholding from entities who had been presented to the market as having been independent placees. And when the balloon went up with the Enigma report and the investigations that followed, when that happened, Mr. Cho wanted to put as much distance between him and the entities he had used to mislead the market. And that distance was put, so alleged in Action 2922, by Mr. Choi acquiring via nominees the shareholding that had been vested in the alleged independent placees. And my lords, I'm not going to take up my time now to show you, but I'm going to give you two references, if I may. The summary of 2922 is paragraph 2, and it's at page 4651. The critical section of Action 2922 for the purposes of Mr. Choi, Francis Choi, is section F, and you'll see that at pages 4731 to 4746. And some of the entities that were whose shareholding was acquired as part of this process by Mr. Choi's nominees were in fact Enigma network entities. My friend says that Enigma has no role to play in any of this. Enigma is all over this. And my lord, to make good that point, can I just give you two references? Paragraph 2, subparagraph 5 of the pleaded case in Action 2922, which is at page 4654, and paragraph 60 at page 4735. So that is Mr. Choi, we say, if I can put it this way, at the end of the story and the allegations that are made against him. Let's go back to the beginning of the story, which is broad idea. And your lordships will, if I can show you this, it's all from Mr. Choi's own evidence that was before Mr. Justice Adderley, and evidence that was before the Court of Appeal, and evidence that is relevant to the issue or likelihood of being able to assert some claim over the assets of broad idea. So that I'm not going to leave your lordships with an impression that we've gone off on a frolic of our own about a company that we have no chance of getting at, if I can use that expression, by way of enforcement of a subsequent judgment from Hong Kong. Now, let's look. We say that broad idea is acting or acted as a nominee or agent. It may be that on further fact analysis, other indications would show that it isn't even properly been operating. But I don't need to go that far, because the way the investments took place was that Mr. Cho approached Mr. Choi to make an investment, not in Broad Idea, but to make an investment in town health. And that is from Mr. Choi's own words, paragraph 24 of his second affidavit, page 2551. He says, Dr. Cho approached me and proposed that I make an investment in town health. Now, my lord, I don't for one moment seek or need to persuade your lordships that I prove an entitlement from this evidence, but simply that it shows that the idea that there is no evidence upon which there is a credible case to get at the assets of Broad Idea, that is the burden I am seeking to meet. In the same affidavit, the second affidavit, paragraph 26, page 2551, Mr. Choi talks about my investment in town health. And then very interestingly, he says, I was attracted to invest in town health because my daughter was very keen on pursuing her interest in the healthcare sector. Now, my lord, again, I don't say anything decisive, but one can get a very clear understanding of where Mr. Choi believes he's investing, and that is in town health. And indeed, if this was to be treated as a separate investment by Broad Idea, then one must question how a director of Broad Idea considers it in the best interests of Broad Idea as a separate legal entity to make an investment in town health for his daughter's sake, without talking about whether it's in Broad Idea's own interest. Again, I don't put the point higher than I need to, but it really does tell you that what's happening here is Broad Idea is incorporated only to affect the prior agreement to invest in town health. Now, I appreciate that parties can, and sophisticated parties very often do, use various corporate entities to carry out their transactions. That is what can happen. But in circumstances where the agreement is relating specifically to invest in town health, and then Broad Idea is only created in order to affect that, we say that that is supportive of a view that Mr. Choi, we don't have any evidence from Mr. Cho, so we need to rely on Mr. Choi's own understanding of what was going on, that this was an investment in town health and Broad Idea was created to enable it to be done. He tells us it was done for the specific purpose of investing in town health. So a legal entity is being created in order to effect a prior agreement to make an investment. And then he says that I've shown you 26 and 28. At 29 of Mr. Choi's second affidavit, at page 2552, he tells us why he became a non-executive director of Town Health. And that was to monitor, quote, my investment in Town Health. My investment in Town Health. This is an affidavit that was no doubt very carefully sworn, and the language used, which if we were in a pub talking about whether you've invested in a good investment, you might very well use language like that if there was a corporate entity in between. But he again is reaffirming what he considers the position to be. Paragraph 30, the next paragraph, explaining why he attended board meetings at Town Health. Why did he do it? He said, I did so to monitor my investment. My investment. Paragraph 31. In any case, my investment in Town Health certainly does not indicate that I committed any wrongdoing. So, and we say, therefore, that there's evidence there that, because we don't have evidence from Mr. Cho, that Broad Idea's assets cannot be so adequately and clearly guillotined from this injunction. Broad Idea is controlled by Roy Cho. Mr. Choi has told us that. when he sought to create the impression that he had nothing to do and was an innocent bystander. We now know that Action 2922 contains those serious allegations against him, which are related to Mr. Cho's own wrongdoing. We also know that Mr. Choi, in an effort to rebut the suggestion that the assets of Broad Idea should be treated as Roy Cho's own assets, has gone to town to tell us that he thinks he's characterised the investment in Town Health as being one that he's made by his use of language like my investment, etc. So then one understands that a considerable amount of money by way of profits will inevitably have flown from Town Health by way of dividends down to Broad Idea. We don't know where those monies are. We then ask ourselves, what about the share swap agreement? That was an attempt, as I say, to excise precisely the percentage number of shares in Town Health, representing the percentage number of shares in Broad Idea held by Mr. Choi. Mr. Roy Cho happily agrees to that, and that it's in the best interests of Broad Idea. How it could be in the best interests of Broad Idea when it is facing this injunction is not made clear. It is said, however, in the balance sheet that the deal can go ahead because its assets exceeded its liabilities. And the problem with that is that the two principal individuals behind Broad Idea also control or have a very significant role to play in the Town Health Group and Town Health International. And Town Health International shares have been suspended since November 2017 and remain so. Why were they suspended? Because of annual reports materially false, incomplete, and misleading information having been given out to the market. So when one asks, well, why are you worried about the balance sheet that's being provided in support of the share swap agreement? That's one of the reasons why, because we don't have full transparency as to Broad Idea's actual status. And it's a well-established principle that one can freeze the assets of a company in order to protect the value of the shares in that company. And that doesn't involve any fancy lifting of the corporate veil, and Mr. Justice Adderley recognised that. It simply recognises the power of the court to make effective its orders, because otherwise, if one simply injuncted the shares, then the assets of Broad Idea could be moved and dealt with in any shape or form, resulting in being left with an empty shell of Broad Idea. Because unless you injunct Broad Idea to stop dealing with its assets, then one is left without adequate protection and cover to make the injunction against the shares effective. And another point, my lords, is which makes my broader point first. And my broader point is that we're heavily criticised by one party who hasn't chose to engage in the underlying allegations and rebut them, but has chosen to adopt a route of nitpicking on various parts. Principally, as you will have seen, twice you've had the allegation of materially misleading and false being put against my paragraph 2159, in which an unfortunate error included Broad Idea in the Enigma network. Twice that's been said against me. Well, let me just say it's unfortunate that it was said without reference to the correction in the statement of fact and issues. That's unfortunate. There's a whole tone that refers that goes through that appendix were materially misleading seems to be a phrase used because the cross-reference is wrong, etc. My lords, if that was to have any bearing, if that document is going to have any bearing on the outcome of what your lordships decide, then given it came in response to my own document, I would want an opportunity to put in a reply comment column to the section that's been put in by my friend. I don't want to trouble you with that anymore because I think we've got more important issues to discuss. But I throw that out if it's considered remotely relevant because I didn't want the tone of the comments. There's one thing saying a mistake's been made, but I don't think we need to go any further than that. But if it would be helpful, then we will deal with it because we don't shy away from defending the document and the underlying allegations. My lords, in terms of the narrower point I was going to make in terms of why we're concerned about the need to protect the underlying value and the share swap agreement and the need for transparency, is that in the Hong Kong proceedings, and let me just make it clear, it would be farcical if this court can take note of the Hong Kong orders, but that you believe you are not entitled to see the reasons which go to support those orders. My friend says you can't take them into account under the Evidence Act 2006. That argument simply doesn't bear water. It was raised and rejected in Great Panorama, a case that you've already been taken to earlier today at 14539, and from my memory, it's paragraph 17 to 28 that Mr. Justice Jack dealt with that point. But the simple answer to it, apart from good old-fashioned common sense, so you can understand why they reached a decision, is that I'm not seeking to prove a fact. We're not at trial, not seeking to prove a fact. And that's why the Evidence Act, Section 90, doesn't apply. But what arose from the Hong Kong proceedings is that there were allegations. The focus there was very much on what recent conduct has Mr. Cho been engaged in from which we might be able to infer risk of dissipation. That was how Mr. Justice Harris approached the issue. And in that context, to explain away various property purchases and remortgages that had taken place when the balloon went up, Mr. Cho said that he paid off Broad Ideas credit facility with Credit Suisse in 2017 of a credit facility of Hong Kong dollars 715 million. Now, the Hong Kong Court of Appeal had some doubts about this arrangement, given what is it the Broad Idea is supposed to be doing with such a facility. If that facility existed, it may very well be further fodder to the argument that effectively Broad Idea is doing the investment work of Roy Cho and possibly Francis Choi. But in this instance, it said that it's paid off by Roy Cho. So a debt would arise from Broad Idea to Roy Cho of Hong Kong 715 million. Now, that was in 2017. There's plainly Roy Cho only paid it off. Let's assume his evidence is true, given the benefit of the doubt. But he only paid it off because Broad Idea was incapable of paying it off. And he acted as one of the guarantors. Mr. Choi apparently was one of the other guarantors, the other guarantor. Now, if that's right, there's a debt that should be somewhere in the books, a Broad Idea, to Roy Cho. And that would be a debt that we would have every right to garnish as part of our enforcement of Roy Cho's judgment. There is also a debt that is in the books, the original loan from Roy Cho to Broad Idea of 41 million Hong Kong dollars, which is, I believe, just under £5 million. That again can be the subject of garnishee proceedings. One can get a receiver in equitable execution to go in and stand in the shoes of Mr. Roy Cho as the majority shareholder and put on a new board, an independent board. I understand that's the practice in the BVI, to install an independent board, and then the assets of Broad Idea, after proper consideration and investigation, can then be sold and distributed. And if it turns out that Mr. Roy Cho is entitled to only part of that, then only part of that will come through. But until we know what part, if it's less than the whole, one can't artificially divvy it up. And if Mr. Choi wishes to get out whilst this process goes on, then is it that, as a separate interest, is fully protected in the usual way by raising the issue within the chapter jurisdiction in the BVI as an issue that needs to be resolved. And it can be done. And in fact, he's put forward an idea that he should be allowed to be bought out. Well, on full transparency, let's have a look and see. But none of this has been gone through because this case was dealt with very much as a jurisdiction case and has shot up the appellate route on that basis. In the ordinary run of these sort of freezing orders and what have you, these issues would be dealt with, excuse the expression, in the wash before the BVI court on appropriate applications supported by appropriate evidence. Turning then, if I may, to some of the other issues that have been raised today, we don't accept that we're getting better rights against Broad Idea that Roy Cho himself has. At this present moment, we don't know what rights he has, save that he has the majority controlling rights over Broad Idea and de facto is in control of Broad Idea, and therefore one needs to preserve the value. But it's not getting better rights. The argument about the needing of a cause of action against Broad Idea is, as I indicated to your lordships yesterday, an attempt by the back door to challenge the power issue. We only get to discussing Chabra in circumstances where I would have persuaded your lordships on the power issue. My friend prayed and aid the reference to cases as a word used in the Section 24 of the BVI Act. We say that that's simply no more than instances, because action, which is what he really wants, is subject to a definition. And one can see that when the court in Section 24 wishes to make clear that they're talking about an action, a substantive action, they use the language. And I'd invite your lordships, just for your lordships note 13472, you'll see the definition of action. And right the way through the Act, one can see where action is used. The response to your lordship's point on anti-suit and knowledge pharmacal, I'm not sure my Lord Reed's question about the comparison with anti-suit injunction in the end ever did get answered by my friend for a Broad Idea. We simply look at these as examples where injunctions are available under the statute, which plainly do not fit squarely within the North London reasoning. It's not to say that the freezing order is an anti-suit or that the freezing order is a knowledge pharmacal. It's to say, as Lord Nichols says, that any idea that one has to squeeze the freezing order into the North London view of an interlocutory injunction is wrong. There are other types of injunctions which go beyond the strict requirements set out in North London Railway. My Lord Legate helpfully referred to the Australian case of PT and buy-in. My Lord, you will see in our statement of case, paragraphs 63 to 69, page 9181, that we engaged in a discussion, helpful I don't know, but a discussion nevertheless, of procedural right and the Australian approach. And what you saw there was my suggesting that the rights-based only approach has the dangers of the Susquehanna and the North London Railway reasoning, and an approach which ignores entirely, apparently, the interests of the applicant, so is purely and only protecting a process, isn't on all fours with the freezing order, in this sense that a freezing order is not a remedy that would be given of the court's own volition. Someone has to apply, and someone has to put up the dosh, if I can put the money where the mouth is, by way of the cross undertakings and possibly fortification. But where we are in at SIG is that the role of the freezing order in protecting the interest of the applicant relates to the integrity, protecting the integrity of the enforcement process that may be called into action. And one needs to persuade the local court that its enforcement process is on the agenda, as I set out at the very beginning of my submissions. And in the case of PT and Banyan, one can see there, it appears that the relevant two parts of the judgments for your lordship's reference, the 42 to 50 and 64 to 78. And there the court took a view that granting a freezing order in aid of a prospective enforcement of a judgment of a foreign court fell within its inherent power to do so. And it didn't draw any distinctions based upon its own separate Australian acts in doing that. It was talking about the inherent power of a court to protect its own process. And in doing so, they expressly supported the analysis of Lord Nichols, saying that there's nothing exorbitant about what he was doing, as he himself said. And the reason why, and I believe my Lord Legate emphasised this point in questions today, the reason why it's not exorbitant is because it needs to be a judgment, but that judgment must be one which is capable of being enforced and will need to be enforced in, or is likely to be enforced in, the BVI. One needs to persuade the BVI, the local court, that there is, in fact, a reason for its involvement, that it has some skin in the game, to borrow that expression, and that comes from the fact that there is conduct which will interfere with its own enforcement process. Yes, as I said at the very beginning, it all comes back, it can be said, well, that's in aid of foreign proceedings. Yes, but actually just look at what it is doing, and the focus of its activity is very much on the enforcement process. And whilst you have Banyan in mind, paragraph 47 sets out the court's understanding of the ratio of the case, Cardeal. And it would appear, notwithstanding the amount of time that was spent on it yesterday, with no criticism, because it's an important case. But ultimately, it came down to whether or not there was a credible basis for CCL to pursue the assets of BI, a broad idea, in the BVI. And for the reasons, the factual case that I've tried to skim over very quickly this afternoon shows you, in my respectful submission, that there is indeed such a case. And you'll see that it's all about may. There is no certainty and definitive here. That's why cost undertakings and damages are given. And the more uncertain the argument, the greater the fortification may be that's required for the cost undertaking in damages. My friend for Broad Idea characterised the restriction in the order, the terms of the order, on the ability to register shares in a way of trying to suggest that I was trying to prevent, by the order, proper registration of that which had occurred. No, what I'm trying to do by the order is to stop the only two people who have ever been shareholders in Broad Idea from involving a third party in an affair which is plainly still to be worked through. Broad Idea's involvement as an animal on behalf of Roy Cho, whether with or without Francis Choi, is plain to see. And Francis Cho's own view of its role and where he was investing is equally plain to see. And it's only these two individuals who have ever been shareholders. So we don't see that there's any real practical force in the point. As regards to Hong Kong orders, unusually, I accept, my lords, that one would typically have a Hong Kong, if we put this in the language of an English worldwide freezing order, typically the English freezing order would come first, holding the substantive proceedings, and then there would be applications around the various jurisdictions that we felt were appropriate. In this case, because Mr. Cho had fled, as the Hong Kong court found, in order to avoid legal process and was missing, and because the manner he held his assets was such that there were no identifiable assets of any substance in Hong Kong, it was necessary for my clients to pursue injunctive relief against the only assets that were known, which is the BVI company that he'd settled and was the majority owner in. So that's how the order of events happened. The order that was granted by the Hong Kong Court of Appeal is an order which talks about his assets being frozen worldwide. So plainly, it's of a much broader scope in terms of territory than the BVI order, as one would expect. But if his assets do in fact include, as we say, is likely to be the case, or there's credible evidence of, the assets in fact held by Broad Idea in terms of the shareholding in Town Health, then the freezing order in Hong Kong would in fact be wide enough to include that. It's not the terms of the order that are that create any conflict. It's whether or not the evidence shows that the assets of Broad Idea fall within Roy Cho's assets for the purposes of the Hong Kong order. And I should also say that it was said against me that there's been no application against Broad Idea in Hong Kong. And I have to say that the parties consented to adjourning the inter-parties application against Broad Idea because, one, there was already an injunction against Broad Idea in the BVI and pending the outcome of the appeal process. And so, my lords, that's why Broad Idea, there's been that particular application hasn't been put forward there. But of course, if one then asks as a matter of practice, Broad Idea is located in the BVI, and therefore that is where an order against Broad Idea will be most effective. Obviously, some of its directors or all of its directors are located in Hong Kong. My Lord Voss.
Have you ever asserted a cause of action, a substantive cause of action against Broad Idea in any jurisdiction?
No, we haven't.
Thank you.
No, we have not. And there have been intimations as to whether or not that might prove to be some step that would be taken, but that is not, I don't rely on any of that. No, Broad Idea is involved in this because it is an entity subject to the control of Roy Cho, holding assets that we believe will be available in one shape or form to enforcement of a judgment against Roy Cho in the BVI.
Can you just explain, just that I'm clear about it in my mind, what the process would be for enforcing the judgment, the Hong Kong judgment in the BVI?
My Lord, as I think my friend Mr. Morgan, I believe it was, briefly outlined, that it's not via any act, because Hong Kong doesn't fall within the terms of the act. So it's your typical English action on a summary judgment. So you bring the judgment over, and then there's an action on summary judgment. So you commence a BVI action, pleading the judgment and seek a summary judgment of that, as you would have done or would do here for, say, in the UK for an American judgment. And then there were very, very limited defences available. But my Lord raises an important point that I haven't addressed, and of course, insofar as it's suggested there are issues that haven't been resolved about broad idea and its relationship with its assets and Mr. Cho, and my first submission would be that they are the kind of issues that are dealt with every day within the regime of the Chabra jurisdiction, and that doesn't cause a problem because they can be out with the trial process, because again, you're not likely to have a trial that deals with the actual issues that give rise to the Chabra jurisdiction for all the reasons I previously suggested. But if that didn't happen, it wouldn't be difficult within the process of commencing an action to freeze the judgment, to enforce the judgment in the BVI, to seek at that stage a declaration that the judgment, being the debt at the end of the day, is enforceable against the assets of Broad Idea. There would be no problems on jurisdiction because of Broad Idea's location, and this reflects a process which occasionally happens, unfortunately, but occasionally happens in England to overcome the difficulties of the service out jurisdiction, depending on whether for a Chabra, when depending on whether cause of action is still ongoing or post-judgment, and some of the authorities speak one way and the other. But sometimes, to avoid the whole issue, you can simply plead a declaration that at the end of the day you're going to enforce, because you say those assets are his assets, etc. And then, but the way I said it, unfortunately, is because at that stage, it's an issue that may or may not arise, and is simply being used in order to overcome any concerns by the absence of a substantive claim. But that would be one way, and that would be an issue. That would be a way for Broad Idea to have any concerns it has litigated. But we don't accept the proposition that was made. The absence of a trial means that the case is never tested. The case is the case, if it's a reference to the entitlement to the relief, never gets tested at a trial, whether or not the proceedings are in the same courtroom, in the same jurisdiction or not. It's not right to see the absence of a trial in the BVI as in any way impacting on the ability to defend oneself. And indeed, looking at it from a practical point of view, a Chabra defendant is one who, by their very nature, has a close connection with those who are involved in the underlying substantive proceedings. So, firstly, the Chabra defendant itself, without that connection, will be able to resolve the issues that go to the core of the Chabra relief, its involvement with the assets, its relationship, etc., whether there's a risk of dissipation by it. Then, insofar as it needs to rely on, if it needs to rely on the underlying CAD, if I can put it that way, that CAD will 9 times out of 10, like in a case like this, be involved in, own, control the very entity that's the subject of Chabra jurisdiction. But if at the end of the day we conjure up a scenario where the Chabra defendant says, I can't, which isn't this case, but the Chabra says, I simply know nothing about the underlying merits of the case, and that's unfair to put me under an injunction when one of the criteria is a good arguable case on a set of proceedings I know nothing. If that very rare scenario were to arise, is that a principled objection to the jurisdiction? The answer to that is no, because look at the Norwich Pharmacal respondents. They don't know whether you have a good arguable case of a possible claim arising from the third party. Do we really think that the customs officer in Norwich Pharmacal, as and when the material went through his little machine, had any idea that he was participating in some underlying cause of action or breach of copyright. No, of course not. So it's not fatal to the existence of the injunction, but of the jurisdiction to grant the injunction. But we say more importantly, it simply doesn't arise on the facts. Black Swan was the subject of a fair amount of criticism, and we've addressed that at 9217 of our statement of case. And I won't take up any more time. But what I would say on Black Swan, my lord, which is that it's not Mr. Justice Bannister on his own going off on some sort of frolic. This is a well-established 10-year jurisdiction, which was endorsed by the BVI Court of Appeal and well received within the jurisdiction. And indeed, what he did, one can see now, is what the BVI jurisdiction wanted by virtue of Section 24A. Turning, if I may, to
before you do, can I just ask Mr. McGrath?
Yes.
I'm asking about this point about recognition. It may seem rather a technical point, but in Mercedes, Lord Nichols several times lays down the test, as he would see it, for the grant of a Moreva injunction in Hong Kong, as being that the foreign judgment, when obtained, will be recognized and enforceable in Hong Kong. Now, we're obviously being asked here to think it is sufficient that the foreign judgment will be enforceable in the BV. Well, yes, enforceable in the BVI through debt proceedings.
Well, sorry, I apologise for cutting across. If your point is, it will be recognised that because without those debt proceedings, because I can plead an issue estoppel based upon those proceedings. But obviously the judgment is most useful when it's enforced, and that requires that process. But the question is not, with respect, my lord, what process one uses to get to the end result. It's
no,
whether...
I'm not suggesting it is. I'm simply noting the way in which Lord Nichols put the point, and noting the fact that in this case we're not talking about recognition in the in the sense one would usually talk about.
Well, there's been no...
But enforcement, you would say, is the crux of the matter.
But, my lord, yes, but I mean, I don't understand what the relationship is between Monaco and Hong Kong, but use of language of so long as the putative judgment would be recognisable and enforceable in Hong Kong would be, in my respectful submission, equally applicable to a Hong Kong judgment in the BVI in circumstances where the only grounds upon which you could contest recognisable and enforceable would be those limited Dicey and Morris, were they there at the time, etc. Of course, none of which have ever been suggested don't apply. My friend has always taken the point as to you have improved your case as regards getting at the assets of broad idea, but there's never been a formal challenge that the Hong Kong judgment in itself would be an unenforceable or unrecognisable judgment in BVI.
I understand.
My lord, turning to one or two points my friend Mr. Mumford made, conscious at the time, we say that our submissions are not about the court taking a different view. We make a fundamental challenge to the view that was adopted in the Susquehanna and in Lord Mustall's opinion in Mercedes-Benz. And we did challenge the actual reasoning in Mercedes-Benz, and I made the point about the heavy reliance on asset-based jurisdiction, because that appeared to be the main thrust of his rejection of the freezing order, on the basis that he says, is that sufficient? No, it's not, because I believe we should have an underlying cause of action. The points about assumption that the Susquehanna is correct, well, it doesn't work with respect. If one assumes that which would be inconsistent with the position you adopt, then that doesn't really help. I mean, what the assumption has done is meant that he hasn't grappled with the very issue that he said it was necessary to grapple with. He says that, Lord Mustall says that. he says you need to grapple. In order to know whether it's within the injunction gateway, one must grapple with the spirit and intention. And then he has a go. He discounts Lord Denning's efforts, recognises on the second one that it's inconsistent with North London Railway, which underpins the reasoning in Susquehanna, and then says, recognises it's a special exception, or says it may fall, as Lord Brandon says in South Carolina, within the special exception, and then says can't take it any further. But just pause. The Susquehanna, as my friends accepted, the ratio of the Susquehanna is all about service out. And its position in respect of service out is premised upon the freezing order being within the North London Railway reasoning, and it isn't. It's fundamentally inconsistent with it. So the unfortunate thing is that the assumption didn't carry with it the force of actually proper examination of what the Susquehanna was all about. Had he given it real thought, and I don't put it that way, but had he considered the consequences of the assumption, if he's right that Lord Denning's the only rationales put forward are wrong, then he's got to be asking, what on earth is this animal? And how can I possibly apply the Susquehanna reasoning to this animal? And we don't accept that he's not, in his reasoning, influenced by the Susquehanna. He plainly starts in that position because he does everything to avoid having to challenge it, which I identify to your lordships in my opening submissions as rather indicative of how loved the Susquehanna is as a decision. I don't deny the skillful efforts of the judiciary to circumvent the need, as and when the situation arises, to circumvent dealing head on with the Susquehanna. But the reality is, one looks at 11758C2E, he appears to rely on the Susquehanna, notwithstanding having said that he wasn't. I hope that's just the right reference. Let me just double check for your lordships. Yes, I mean, whatever else may be said about the current standing of the Susquehanna, it's not so far been reversed by anything, as shown by the decisions of the House of Lords, etc., etc. So he supports, at the end of the day, the conclusions he reaches by reference to, and the Susquehanna still stands. And my proposition in these appeals is that it shouldn't, in respect of service out. I obviously accept that, and Lord Mustall clearly takes the view that if Lord Nichols's approach is correct or adopted in a case, the one then needs to look at the gateway. Now, I challenge him on the looking at the gateway only by virtue of the legislation, but it's quite clear that he takes the view that one would need to re-examine the gateway. And your lordships had the quotation from Lord Hailsham in the Susquehanna, who couldn't see that if this was actually what a freezing order does, couldn't really see why it couldn't go ahead. Didn't have any problems, there were no constitutional issues, etc. We accept, of course, that the decisions of the board reverberate around the common law world, but that only emphasises the need to ensure that those decisions are correct, that the reverberations are in the right way. And although my friend pointed to some examples of cases relying on or following the reasoning of Mercedes-Benz, I wouldn't expect anything else. It's a decision of the board, and therefore it is highly likely to be followed and applied. But let's not forget the almost universal support of the reasoning of Lord Nichols in commentary. One must really look back and ask how many judgments, if one can properly call it a dissenting judgment, how many dissenting judgments are cited more, it seems, for the reasoning than the majority reasoning. Powerful, compelling, the sort of descriptions that one gets from Dicey and Morris. And we don't accept that it leads to some difficulties of wider unravelling, because we're talking about the availability of the injunction gateway for specific freezing order relief. Our appeal can't be boiled down to and minimised to one of policy only. I was very keen to show you the cases and to run through arguments, not all of which have been addressed. My Lords, as regards the precedent issue, it is right that we referred in our statement of case to the extract from Lord Manson Turner's book on Privy Council, and that's at paragraph 30 of our statement of case. I'm afraid I don't have the page reference. And we say that plainly, the most important reason for departing is that we say it was wrong. That's the most important reason. But then one asks, well, is there any other reason? Well, yes, there are. I believe the expression is that there are down islands in the Eastern Caribbean, Nevis, Anguilla, etc., who are all bound by that reasoning. And if your lordships were to accept that it was inaccurate and incorrect reasoning, then one ought to ensure that clarity is put where there is uncertainty, and certainly where there is error. And the correct decision should be the subject of your lordship's decision. Let me just have a little look. My Lord Sales rightly raised the point about the standalone interim relief in the writ in the Channel Tunnel. And when one sees what Lord Mustall was doing in that case, he was making it quite clear that that was a writ being issued solely to assert jurisdiction over the interim relief, that there was no conflict with the underlying, if it was a foreign jurisdiction. In that case, the facts were obviously an arbitration, but he was talking more generally. And says that you can have a writ with sole relief being interim relief. And we say that that is what we, if one can have an originating process on that basis, as set out in Channel Tunnel, then freezing order relief can clearly fall within that as well. My Lord, as regards the, if I can put it, the chameleon point, we say that that just doesn't work. If the freezing order only falls within the, only arises because it falls within a gateway itself and there's no underlying cause of action, then it needs to satisfy the requirement of that gateway. But if the jurisdiction is already engaged by virtue of the cause of action being subject to a gateway, then there's the freezing order is then the jurisdiction of the court already engaged, and the ability to grant a freezing order and the power to grant a freezing order exists. And of course, it's not then a freezing order that would be limited by its terms that are set out in the injunction gateway. So we don't accept that one can say, well, if you can serve a freezing order out under the injunction gateway, you must only then be able to get that every time. If you already have a separate underlying cause of action, you must also go through the injunction gateway. Although the reality is it'd be difficult to perceive too many circumstances where one wouldn't also be able to fall within the injunction gateway if there was an underlying cause of action within the jurisdiction of the court. And my final point, my lord, is that
Mr. McGrath.
Oh, sorry.
Just before we move on from Mercedes-Benz, the submission was made that there are passages in the opinion of Lord Mustall in that case which make it, sorry, it is Lord Mustall, isn't it? Which make it clear that the assumption for the purposes of the reasoning of the majority was being made that the Susquehanna on the power issue might be wrong. For instance, page 11751. And again, it appears at the end of the speech where it said, should a time arise where it's recognised that the subpoena is wrong, and that freestanding moreover relief may be available, then the rule committee should look again. And
Yes.
it is perhaps worth bearing in mind that, as in Channel Tunnel itself, Lord Brown-Wilkinson had made comments which were, if you like, very critical of the Susquehanna and the way in which it didn't marry up very well with use of injunctions to police proper distribution of proceedings on an international basis. So I just wanted your comment, because it might be said, and indeed it is said against you, that the majority of Mercedes-Benz looked full in the face the position which is being advanced on the power issue by yourself, and said, well, notwithstanding that, the rule cannot be read in a way that you contend for on the rule construction point.
And as I was rather inadequately trying to explain earlier, my lord, my answer to that would be that the assumption unfortunately meant that they didn't grapple with the significance of the Susquehanna. Just to simply say, well, let's assume the Susquehanna got it wrong and move on then to assume we've got the power. That doesn't help, because as I was trying to show in my opening submissions, that the consequence of the error on the power issue impacted the answer on the service out jurisdiction point in the Susquehanna, and that to simply assume, okay, you've got the power, doesn't result in you analysing what that means. I mean, that's one of the points I make as to why the appeal still is important, notwithstanding section 24A, because in order for your lordships to grapple with whether or not you're within the injunction gateway, you need to know the nature of the animal that you say does or doesn't come within. That's what Lord Mustell tells us. And that didn't get grappled with by the majority. And it didn't get grappled with because they avoided it by just assuming that the answer was right.
Could I ask you? Oh, I'm so sorry.
No, my lord. My lord.
Could I ask you one other question arising from the majority judgment in Mercedes-Benz? And it goes to this issue of intent. Might it not be said that it's a major step for legislative action to be taken by any country to assert extraterritorial jurisdiction for its own courts? And part of the theme, it might be said, of the majority judgment in Mercedes-Benz is that is a step which one would expect the Parliament or the Rules Committee to take, if you like, with their eyes open, as a very deliberate step to invoke extraterritorial jurisdiction. And one of the problems about the assumption that was made for so long was crystallized, if you like, in the Susquehanna, but persisted after the Susquehanna, was that there simply was not a power to grant a freestanding moreover, and that therefore to construe the rule as covering freestanding moreovers would in effect lead to the exercise of extraterritorial jurisdiction without the relevant legislative body looking at that with its eyes open and deciding, yes, we want to do.
Well, in the UK, I don't think it would take a legislative body because of the point I made the other day, that it's practice direction stuff these days. And the reason why it's practice direction material is because the gateways are subject to the filters, which is why you would only end up with the freezing order being sought against a non-BVI individual in an appropriate case. It would only be granted if it fell into a case which proved that the BVI was the appropriate jurisdiction to grant that relief. And it wouldn't be just, well, possibly there's a freezing, the enforcement process may be called into action, one would need to give it a good case as to why the BVI should be involved and no one else. So the filter of the forum convenience is an important filter. Your Lordship has the Australian case and the general consensus that because what I'm proposing in these appeals is very much tied up with the prerequisite that the judgment is and is likely to be enforceable in the BVI, that it's not considered to be exorbitant in the sense of your Lordship's referred to in terms of exercising extraterritorial power, because the terms of the gateway limit the conduct, and the conduct relates to the protection of the enforcement process within the BVI. So one wouldn't be using this gateway to act as an international policeman, having no connections with the BVI, as one might do under other gateways. So my Lord, I would say that this is a freezing order for a limited purpose, fitting within the plain and natural meaning of the words, based upon its own, our proper understanding, and it's the understanding of the freezing order that I say is not controversial, not the significance of recognising that, but the understanding and the role it plays is not controversial.
Yes, thank you very much.
Yes, Mr. Morgan, are you wanting to intervene?
My Lord, yes. My learned friend Mr. McGrath began what was meant to be his reply with an extensive development of the facts,
Yes.
which was not reply, and to which I would request the indulgence of the committee or the board for a very, very short answer.
Well, it's would you rather answer answer orally, or would you rather put it in writing?
I can do it orally now in no more than 5 minutes.
Yeah, well, and I assume you're just about finished, I presume, Mr. McGrath?
My Lord, yes.
Yes. Well, is there anything more you need to add, Mr. McGrath, to your reply?
My Lord, the only point I would say is on the question of claim form, the very fact that under the legislation, for example, section 25, that in respect of the interim relief, one still uses a claim form and still has affidavit requiring all the usual criteria, shows that there's nothing substantive in terms of the inability to have freestanding relief within a claim form. And that therefore, if your Lordships were to recognise that power and that it fell within the gateway, as we say at the end of our statement of case, that is a matter that the BVI court could readily rectify. And the point to take from Great Panorama is Mr. Justice Jack's recognition that there's, now that the law was clarified, he said, it's it's understandable that an application notice had been used there rather than a claim form. Had we used a claim form, no doubt somebody would be telling us the focus of the allegations would be that you wrongly used a document that didn't claim a cause of action. So we say that that's not a bar to where we need to go on these appeals, and it can be dealt with in the BVI court.
Thank you very much. Yes, Lord Hamlin.
Mr. McGrath, what do you say about Mr. Mumford's point that the order you obtain goes beyond the terms of the injunction gateway?
My Lord, that point, I believe we addressed that in our statement of case. Let me just get it. But the upshot, what we say is we rely upon the Jersey case of Crone, because in that case the same point arose there, and the court said that it's page 9249 of our submissions, paragraphs 274 to 276, and the reference there has got Crone. Basically, if the impact of the decision, if the decision impacts or the conduct impacts on the assets within the jurisdiction, then we say that would fall within the terms. If, however, that's to be challenged, then that is precisely the sort of revision of the terms of the order that one would typically have in front of the BVI court, it's not a principled objection to the order. And to use an expression that was used by my friend, you wouldn't throw the baby out with the bathwater if you're going to put it down, but that should be subject to the BVI looking after its own orders.
Thank you. Yes, Lord Legate.
I just want to say, Mr. McGrath did say that he wanted an opportunity to respond to where he'd been accused of making misleading or inaccurate statements. And if he is going to do that, it might possibly be that Mr. Morgan could reply to that. I don't know. I'm not wanting to shut him out, but there has to be further submissions on the facts.
My Lord, I would just simply say that I was responding to Appendix whatever, Annex A. I think my friend wants to reply to whatever I said today on the facts. It could very well be that the simple shortcut is we put in a response to the Annex A, and my friend puts in his response to whatever I've said today. What I don't want is, I'm afraid, being left where he responds to what I have to say. That I don't want.
Well, I emphasise that this board is not ultimately focused on the facts, except insofar as facts have been found by the court below us. It sounds as though in the circumstances, the best way for you to resolve this is for you both to have time to put in written submissions to add to the 250 odd pages that we have already. If I were to ask you to do that within the next 7 days, would that give you time to do that?
Lord, I think it'd be sensible to give us that short time so that we keep it short. And if you could give us a page limit, my Lord, that would also be helpful.
Yes.
My Lord, I've indicated that I would be very short. I'm really short.
Yeah. I think if I set a page limit of 10 pages to be submitted within 7 days, that should be sufficient.
Grateful, my Lord.
I'm grateful, my Lord.
Well, despite those last exchanges, we are grateful to all counsel and assistants. This is obviously a case which raises, whether or not we answer them, it raises fairly fundamental questions. So we're grateful for the assistance we've been given. We'll now consider the matter and decide what advice we shall humbly tender to Her Majesty.
Thank you, my Lord.
We'll now adjourn.
Thank you, my Lord.